Good evening. Welcome to the Analyst. Today we'll be taking up 5 newspaper articles from the Hindu and the Indian Express and analyzing them. The handout for the same will be available in the description of this video for your kind perusal. Please have a look at that. The first article that we'll be discussing today is related to caste survey in the state of Bihar as well as a Madras High Court judgment on reservation in minority educational institutions. This second article is related to the geopolitical analysis of Taiwan, its significance and India's interests in the region. The third article is regarding the implementation of MGNREGA scheme in the state of West Bengal as some irregularities have been highlighted there. The fourth article is regarding the prison reforms as a Supreme Court committee has observed the high number of death cases in prisons due to unnatural causes. And the final article is related to the Nobel Prize in the field of medicine. Let's come on to the first article, which is related to caste survey in the state of Bihar and also a High Court judgment regarding the reservation in minority educational institutions. This is important in the paper GS2. Now, the context behind it is that Bihar government has released the report of a caste survey conducted in the state, and also in a separate article, Madras High Court has ruled that educational institutions run by religious and linguistic minorities need not follow the rule of reservation with respect to SC, ST and OBC communities. Let's talk about the caste survey in the state of Bihar first. Let us look at the findings first. If we observe, the share in population of the backward classes in the state of Bihar is more than 60%, of which extremely backward classes account for almost 36% in the state, whereas the unreserved population, that is the population belonging to the general category in the state, accounts for only 15.5% in the state. Now there are some concerns regarding this survey. Let us talk about the concerns first. Here the first concern is whether it is a survey or a census. If it is a census, then this is beyond the legislative competence of the state government, because census falls under the legislative domain of the parliament, and if a census is conducted by a state government, then it infringes upon the legislative power of the parliament. It infringes upon the right of the parliament. The second concern is regarding the right to privacy and data safety. What if that data falls into the wrong hands? Although the state government of Bihar submitted an affidavit in the Patna High Court that the data will be securely saved under a safe digital infrastructure. And also there are concerns that this data may be used for vote bank politics and it might cause polarization in the society, as the reservation which is provided for the backward classes, SCs, STs, all included, is about 50% only, whereas they account for around 85% of the population in the state. Another school of thought is that the state does have a legitimate aim of ensuring development along with justice, so that there is equitable justice, there is equitable opportunity which is provided to all the sections of the society to develop. But at the same time, it can cause fragmentation, it can cause polarization also, because this reservation rules, they have to be balanced along with Article 335 also, which enjoin upon the state to ensure that the administrative efficiency is not impacted adversely when the reservation is provided under Article 16 subclause 4. Under Articles 15 subclause 4 and Article 16 subclause 4, the state can make special provisions for the advancement of the socio-economically backward classes in the state. Another concern is that if reservation is changed as per this caste survey in the state of Bihar, it might lead to the breach of 50% quota ceiling, which was the rule, which has been the rule ever since the Indira Sahni judgment in 1992. Although there have been exceptions which have been created ever since. For example, after the 103rd Constitutional Amendment Act, EWS reservation was provided, that is, reservation in favor of the economically weaker sections in the country was provided, whereby it was justified by the Supreme Court that EWS this does not come within the 50% ceiling which was supposed to be there for the backward classes. The EWS, they constitute an entirely different class altogether, and therefore this is constitutionally valid. And also the 50% ceiling which was proposed through the Indrasani judgment, it has although stood the test of time, it has been there since 3 decades, but it is not inviolable for the times to come. Therefore, it can be done away with. Special provisions can also be made. But there was a minority judgment in the same EWS judgment also that this can open the gateway for future infractions also, and the minority judgment thereby warned against it. Another exception was created in the form of 76th Constitutional Amendment Act, whereby the Tamil Nadu reservation law was inserted into the 9th schedule of the Constitution, thereby making it beyond the judicial purview, and hence it was guarded immunity through Article 31A of the Constitution. And another proposal was made through the Maratha reservation, whereby the Maharashtra government provided reservation to the Maratha community, and again there the reservation exceeded the 50% limit of the Indrasani judgment, and this was subsequently struck down by the Supreme Court. Now, let us also talk about the Indrasani versus Union of India judgment. What does it say essentially? It said that Article 16 subclause 4, whereby the state can provide for reservation in favor of socially and economically backward classes, this is not an exception to Article 16 subclause 1. Article 16 enjoins the state to ensure that there is equity which is provided in the matters of public employment. Now, Article 16 subclause 4 provides for a reasonable classification, and hence it is valid. It is not violating Article 14, which is right to equality, or Article 16 subclause 1, but there should be a limit of 50%, that is a ceiling of 50% should be there to ensure that one, administrative efficiency is not adversely impacted, that is the duty of the state under Article 335, that is also not violated. And also to ensure there is no reverse discrimination, that is no discrimination is there against the unreserved category. And another provision which was ensured through the Indrasani judgment was to exclude the privileged communities, that is to insert a creamy layer in the reservations to ensure that the non-deserving, they do not get the benefit of reservation. Therefore, this caste survey which was conducted by the Bihar state government, this is being termed as being political, and it is conveniently timed as the results have been announced before the Lok Sabha elections of 2024. Now let us come on to the analysis of the second article. In the second article, the Madras High Court has observed that the minority educational institutions, they need not follow the reservation policy with respect to the SC, ST and OBC students, because the government cannot compel them to implement the reservation policy with respect to these. And their minority status cannot be restricted. That is, once a minority educational institution is granted the status of being a minority institution, it cannot be restricted to a particular period. The minority status can only be taken away by the National Commission on the Minority Educational Institutions, and that too after a reasonable procedure. For example, if the very character of the minority institution is lost. And also the court observed that the religious and linguistic minorities, for them reservation up to 50% of the sanctioned intake can be provided, and rest has to be taken on the basis of merit. Also, Article 15 subclause 5, which was inserted into the Constitution through the 93rd Amendment Act, specifically excludes minority educational institutions from being compelled to follow the provisions made by the governments to ensure the advancement of the socially and economically backward classes under 15 subclause 4. The definition of private educational institution under Section 2D of the 2006 Act also excludes minority institutions established under Article 30 subclause 1. Let us also look at the history of case laws which have helped us interpret the reservation in minority educational institutions. One is regarding St. Stephen's College versus University of Delhi in 1992. Here the Supreme Court observed that in the minority aided institutions, 50% reservation can be provided to the students belonging to the minority category to maintain the minority character of the institution. Also in Satyambala Sharma versus St. Paul Senior Secondary School 2011, the Supreme Court observed that unaided minority educational institutions do not come within the definition of state under Article 12. And because there is no administrative control of the state over them, they are accorded autonomy under Article 30 subclause 1, and because they are not under the definition of state, therefore they cannot be compelled to follow the public law obligations of the state under Articles 14 and 39D. 39D is to ensure equal pay for equal work for men and women. When we talk about the admission to the minority institutions, there have been a series of Supreme Court judgments. One is the Modern Dental College and Research Center versus the state of Madhya Pradesh in 2009, whereby the court observed that in unaided minority education institutions, there is a right to devise a rational manner, a manner in which they are going to admit the students. But this is not an absolute right. A certain degree of state control has also to be ensured, because it is the state's duty to ensure high standards, especially in all professional educational institutions. In TMI Pai Foundation versus the state of Karnataka in 2003, the court observed that in aided minority education institutions, there is a right of minority for the reservation, and the reservation policy of the state cannot be imposed upon the minority educational institutions, whether they are aided or unaided. In the PA Inamdar versus state of Maharashtra case in 2003, again this entire gamut of the laws were discussed in detail, and the court observed that the right conferred by Article 30 was more in the nature of protection from the regulatory provisions which the state may create. And this regulatory legislations, for example, under Article 19 subclause 6, which talks about the freedom of trade, but still they were not immune from the regulatory control. Even within the scope of Article 30 subclause 1, there is a need for imposing reasonable restrictions. And these reasonable restrictions, such directions, they would not vitiate, they would not hurt the right of the minority educational institutions to govern themselves, to administer themselves. Furthermore, in Christian Medical College Vellore Association versus the Union of India 2020, recently this was the case related to the NEET admissions, the court observed that NEET cannot be said to be an unreasonable regulatory framework. Here the court observed that Article 30 is in consonance with other parts of the Constitution. Therefore, the regulatory measures, the regulatory procedures, they do not impinge upon the right of the educational institutions which are guaranteed under Articles 14, 19, 1G, Article 25, which is the right to freedom of practicing, professing and propagating religion, and Article 30 itself too. Now, in conclusion, you can give some broad ideas, some thoughts. For example, the educational institutions, they are the temples of learning, and high standards will flourish if there is academic efficacy. If merit is ensured in the institutions along with reservation, then they can become the epitomes of academic excellence. Otherwise, there will be mediocrity which will prevail. And the institutions, they should use their constitutional rights, for example under Article 30 subclause 1, judiciously, and they should administer honestly. The second article is regarding Taiwan reunification. This is important in GS2 in effects of policies and politics of developed and developing countries and its impact on India. Now the context behind it is that Chinese military has recently released a short film on its National Day on Taiwan reunification, emphasizing its determination to bring self-ruled Taiwan into the fold. Now, before talking about the current situation, let us go into the historical background of Taiwan and its relationship with China. Taiwan is a strategically located island. Before 17th century, it used to be colonized by different powers. In 1895, it was ceded to Japan. Subsequently, in 1945, it was returned to China after the World War II. Then in 1949, the Chinese Civil War ended. After the end of this civil war, the Republicans, they won, and subsequently they formed the government on the mainland China by the name of People's Republic of China. And the nationalists, they fled the mainland and they settled in Taiwan. From there, they continued to claim the control over the entire China. The nationalists, they claim sovereignty over all of the China. Now, because of this, China has always regarded Taiwan as a renegade province that must be reunited with the mainland, even if by force, if necessary. And meanwhile, Taiwan has established a kind of its own democratic system, and now it is even seeking international recognition as a separate sovereign state too. When we look at it geographically, it is bounded by East China Sea in the north, and it is separated from China through the Taiwan Strait, and it borders Pacific Ocean as well as South China Sea. Now, let us talk about the roles of China and the role of USA as well before coming on to the Indian interests, Indian stakes in the region. The Chinese concerns are mainly regarding the Taiwan's activities. For example, Taiwan's President Tsai Ing-wen, they are moving towards a formal declaration of independence. And this is like a red line which could trigger a military response from China, and the growing ties between Taiwan and the United States. This is again causing tensions in China, within the domestic circles of China, because USA adopts a policy of strategic ambiguity. This policy essentially means that USA does not clearly state whether it will come to the defense of Taiwan if China attacks Taiwan militarily. But on the other hand, it also sells weapons to the state of Taiwan too. Then Taiwan's role in first island chain is also of concern for China. This first island chain is essentially important. This is a series of islands in the Pacific Ocean which is important for the US foreign policy to maintain its security interests in the region. Also, Taiwan's semiconductor chip manufacturing industry, this is again like an asset, and Taiwan is a global leader in semiconductor chips fabrication. For example, the TSMC, the largest Taiwan semiconductor manufacturing company, it has capabilities to manufacture chips, to fabricate semiconductor chips to the size of even 3-4 nanometer chips, whereas Intel, its giant competitor which is based out of USA, it is not able to bring down the size of its fabrication of chips below 7 nanometers, etc. But USA has also played a role in this. One, USA used to support the nationalist government of Taiwan in 1949, and it even refused to recognize the Democratic People's Republic of China, the mainland China, till 1979. After 1979, US switched diplomatic recognition from Taiwan to People's Republic of China following China's One China policy. Now this One China policy essentially means that there is only one China, and it means Taiwan is an integral part of China. Also, but at the same time, USA also passed the Taiwan Relations Act. Although it recognized the People's Republic of China, but through the Taiwan's Relations Act, it continues selling arms to Taiwan too and ensuring that its security. It also maintains a policy of strategic ambiguity, and it gives military and diplomatic support to Taiwan in the form of frequent air and naval patrols. Also, there are high-level delegation visits to Taiwan from USA. It treats it like a democratic partner and a counterweight to China's influence in the Indo-Pacific region. Therefore, China has concerns. Now, what are the Indian stakes in the region? One is regarding trade. More than half of India's trade in the Indo-Pacific region passes through the South China Sea, and Taiwan borders it. Second is regarding security. We have common security concerns with Taiwan, such as China's assertiveness, cyber attacks, and the disinformation campaigns which are launched by China and the Chinese keyboard warriors. Regarding democracy, we have common values of freedom, human rights, and the rule of law which we share with Taiwan. Regarding technology, Taiwan can be of immense help to us because it can support our startup ecosystem and our digital transformation journey. Regarding culture, we can engage with each other in the areas of tourism, education, and people-to-people contacts. Now, what has been India's stand till now? We have maintained a diplomatic relationship with Taiwan since 1995, and Although we have not recognized Taiwan as an independent sovereign state, but we continue our diplomatic relationship and we believe in peaceful resolution of the cross-strait issues through negotiation, through dialogues, etc. The next article is regarding the MGNREGA scheme. This is important in GS2, welfare schemes for the vulnerable sections of the population by the center and states and their implementation. The context behind it is that RTI queries have revealed several irregularities in the implementation of the Mahatma Gandhi National Rural Employment Guarantee Scheme in the state of West Bengal. Before talking about the performance of the scheme, let us first talk about the scheme briefly and how it is a paradigm shift. One, the Employment Guarantee Scheme is a demand-driven scheme. It is a social security measure essentially whereby 100 days of work is provided to anybody who demands work. Unskilled work is provided and this is provided per household in a financial year. The eligibility here is simply 18 years of age minimum and the person who is demanding the work should be a rural resident. Let us look at some data also regarding the scheme. This is the world's largest anti-poverty program and as per the socio-economic caste census 2011, 40% of the rural houses have landless people and they are essentially dependent upon the manual labor and they are benefiting from the MGNREGA scheme. 7.6 crore families have active job cards and as per the NSSO data, National Sample Survey Organization, the areas with low consumption expenditure, they have a high demand for the MGNREGA scheme. Women, SC and ST beneficiaries, they have increased over a period of time. As of now, women account for almost 47% of the beneficiaries, whereas the scheduled caste and the scheduled tribes, they account for about 51% of the beneficiaries of the scheme. Now, how is it a paradigm shift? One, this is a framework which is based upon the rights-based framework. Earlier, there was no right to work. There is no explicit right to work contained within the constitution. But here it is a rights-based framework. If the work is not provided, then the person can ask for an unemployment allowance after 15 days of the demand. And essentially, since this is a demand-driven work, therefore resources are transferred from the center to the states as per implementation. And the scheme is also self-targeting because the people can seek work. This unemployment allowance is provided within 15 days of the demand if the work is not allotted. Also, there is a bottom-up approach which is being practiced. For example, essentially it is the Gram Sabha which chooses the nature, which chooses the work which is to be done under the scheme. For example, maybe regarding creating agricultural assets like water ponds, etc. And it is ensuring grassroots democracy and upholding the ideal of Swaraj in real sense. When we look at the transparency and accountability, there are provisions regarding social audit and proactive disclosure on the portal. Now let us look at the performance of the scheme first. One, it has increased the rural wages. Since inception, since 2005-06 onwards, the rural wages have increased by 81% as per a survey. And it has reduced the distress migration. For example, about 5 crores households are on an average employed under the scheme. And it ensures risk mitigation also. For example, when the rain is scanty, for example, when there is drought-prone conditions, then there is higher demand in MGNREGA. There is usage of barren areas for cultivation and creation of assets like ponds. For example, in the past 15 odd years, about 30 million water ponds, etc. have been created. But there is another school of thought which says that it is diverting manpower from agriculture, although it is debatable. As per the NSSO report, it is empowering the weaker sections. For example, the beneficiaries from the women, SC, ST, they have increased. And the Forest Rights Act FRA beneficiaries, for them the work which is allotted is for 150 days rather than 100 days, and it ensures the financial inclusion too through the direct benefit transfer. It has improved the human development indicators in general through ensuring improved food security, nutrition and income. And because of this income increase, the prevalence of child labor has also come down. These are the major impacts. Now let us look at some suggestions also for the improvement in implementation, because there have been reports regarding irregularities like ghost beneficiaries and delayed payments, etc. One, the work under the MGNREGA scheme, it can be expanded. As of now, only unskilled work is provided, but semi-skilled work can also be explored. That can also be provided in the scheme. For example, desiltation work, etc., which is explored in the state of Tamil Nadu. Then we can explore upskilling also. For example, it can be converged with Deen Dayal Upadhyay Gramin Kaushal Vikas Yojana, and even the self-help groups, they can also be involved in the implementation of the scheme. For example, Kudumbashree in Kerala. We can promote the uses of JAM Trinity, including insurance coverage as well with the scheme, and the Gram Sabha should remain the focal, for example, in the state of Meghalaya. The social audit can be institutionalized also, as is done in the states of Andhra Pradesh and Telangana, and a performance audit can be conducted by CAG regularly. Then grievance redressal mechanisms should be put in place, where a mechanism can be put in place whereby a complaint can be put in against the erring officials. The wages which are provided under MGNREGA, they can be linked with inflation, they can be inflation indexed, and the funding can be increased, because the allocation of funds, it has to be as per the requirement, else it will lead to the delay in payments, which will cause malnutrition, hunger, and increased prevalence of poverty in the rural areas. We can use drones, etc. to track assets, as is done through the geotagging of assets, and the convergence can be institutionalized, for example, in Tamil Nadu again. Now, the next article is regarding the prison reforms in India. This is important in GS2 important aspects of governance. The context behind it is that the Supreme Court Committee on Prison Reforms has found suicide to be the leading cause of unnatural deaths among the Indian prisoners. Now, before moving on, let us talk about the challenges in the prison reforms. Prison is a state subject essentially in India. Therefore, the state governments are bound to govern the prisons under the 7th schedule of the Constitution. The challenges include that they are governed by an archaic law, that is Prisons Act 1894, and the prison manuals of the state governments, they are used for the governance of the prisons. Also, recently the Supreme Court has observed that the classification of the deaths which are caused in prison in custody, they are vague. The distinction between natural and unnatural deaths, that is vague. Natural deaths include due to illness, etc., and unnatural deaths include maybe due to suicide or due to violence between inmates, etc. And there is an overcrowding in the prisons. As per the data by NCRB, the National Crime Records Bureau, the under trials, they account for 69% of the total prison inmates, and there is an oversaturation in the prisons by almost 118%. Also, there is a pendency of cases, almost 4.7 crore cases are pending in India, and infrastructural constraints, they force the prisons to ensure that the under trials and the hardened criminals, they are staying in the same cells. And there is a lack of human resources too. There is understaffing, there is essentially lack of empathy, apathy, etc. And the female staff is severely understaffed, and the training is lacking. The human rights violation cases have also come into picture. For example, the custodial violence cases, they account for about more than 1800 cases recently. And the economic background is also to be considered here, because there is a linkage between poverty and the population of inmates, and because of this poverty, they are not unable to post bail, they are not able to afford the litigation costs, the lawyer fees, etc. And the situation regarding women and children, that is even more pathetic in jails. What another big challenge is regarding the reintegration of the inmates, the prisoners, with the society after they are released. Now, what are the steps taken regarding the prison reforms in India? One is the modernization of prisons project 2021 to 2026. Hereby we are adopting modern security equipments and automation. This ensures that technology is adopted. E-Prisons project is another step, and Modern Prisons Manual 2016 also governs the prison reforms. The Amitav Roy committee has also suggested various measures. For example, it has observed that there should be a speedy trial. The right to speedy trial is also contained within Article 21, the right to life and liberty, as observed by the Hussainara Khatun versus the state of Bihar case also. And the committee observed that we can promote plea bargaining in India. Plea bargaining essentially is a concept whereby an accused admits to committing the crime. And because he is admitting there won't be any trial, the state will be saving resources from the trial, and the victim will also be spared from the mental agony which is caused through the trial. Therefore, essentially the accused, if he admits to committing the crime, he is awarded a lesser punishment through plea bargaining. The concept of plea bargaining is also allowed within the Indian legislative provisions. For example, under CRPC, it is allowed for the compoundable offences, the offences whereby a compromise can be reached upon. Then the committee also suggested the setting up of special fast track courts for certain crimes so that there is no unnecessary burden also. Now, what are the reforms needed in the prison reforms in India? Now, the philosophy of Indian criminal jurisprudence is not based upon retributive justice. It is based upon reformative justice, rehabilitative justice. Therefore, we can explore the implementation of the modern prison manual first, and secondly, they should be trained in skill building and vocational training should be given. For example, subsequently, there is better integration in the society after they are released, as also recommended by the Mullah Committee in 1983. The integration can also happen if there are semi-open prisons, and there can be collaboration which can be achieved with the help of NGOs, the non-governmental organizations. And psychological counseling should also be provided to ensure their mental health and well-being is up to mark. Then independent prison oversight bodies can also be set up to ensure that there are no human right violations in the prisons. The prison infrastructure and living conditions that can be upgraded, as was also recommended by the Malimat committee. And we can adhere to the international norms too. For example, the Nelson Mandela rules, they prescribe for the minimum standards for the treatment of people. Even the prisoners, they are also human beings, their rights also cannot be violated. And the Bangkok rules, they are especially for the women prisoners. Now, the recent reform is in the form of the Model Prisons Act 2023. The Prisons Act, the Archaic Prisons Act 1894, it has a focus on keeping the criminals in custody and enforcing discipline and order in prisons with no provision for reform and rehabilitation. The Model Prisons Act 2023 seeks to take out this lacuna. It ensures that there is a security assessment and segregation of the prisoners and individual sentence planning and grievance redressal, and there should be an establishment of a prison development board, and the focus should be on physical and mental well-being of the prisoners, ensuring essentially that there is reformative justice. There should be a use of technology in the prison administration, for example, uses of video conferencing in the court trials, etc. And the establishment and management of high security jails, open and open and semi-open jails, and the protection of society from the criminal activities of the hardened criminals and habitual offenders. There should be provisions for legal aid to the prisoners, as is also provided by Article 39A of the Constitution, and provisions for parole, furlough and premature release based upon good conduct to incentivize good conduct, to incentivize reform, to incentivize rehabilitation and reintegration as well. And vocational training and skill development should also be provided to the prisoners, again to ensure their reintegration. The next article is regarding the Nobel Prize in Medicine. This is important in GS3, developments in science and technology and their applications. The context behind it is the Nobel Prize in Medicine or Physiology 2023 was awarded for the technology that enabled the development of mRNA-based COVID-19 vaccines. Now, vaccines till now, they were using weak or inactivated viruses. Those weak or inactivated viruses were injected into the body and that triggered the immune response. Essentially, the body through that weak virus learns to fight it off, so that when the actual virus infects the body, it has learned by that time to fight that off. Now, mRNA cuts that development time also. Now let's go back to the basics first before discussing about the working of the mRNA vaccines. RNA or the ribonucleic acid is a nucleic acid present in all living cells that has structural similarities to DNA. Now what is the role of RNA first? It takes instructions from the DNA in the nucleus to the ribosomes where proteins are made in the cytoplasm of the cell. And the RNA picks up specific amino acids from the cytoplasm of the cell and delivers them to the ribosomes where the protein synthesis takes place. It makes up around 50% of the structure of the ribosomes. Now, messenger RNA or the mRNA is the single-stranded RNA in the protein synthesis, and mRNA carries protein information from the DNA in a cell's nucleus to the cell's cytoplasm, which is the watery interior of the cell. Now this protein making machinery reads the mRNA sequence and starts making it. Now how does mRNA vaccine work? It uses mRNA to deliver a message to the immune system. This genetically engineered mRNA can instruct the cells to make the protein needed to fight a particular virus. This was also used during the times of COVID. For example, Pfizer, Moderna, etc. They were using mRNA based vaccines. And it carries the genetic code for the protein that make up the non-lethal but the key parts of a virus. Now, how does it work essentially? The coronavirus is like the one that caused COVID-19. They are named for the crown-like spikes on their surface and they are called the spike proteins. And these spike proteins are ideal targets for the vaccines. Now what is mRNA? mRNA is essentially a genetic material that tells your body how to make these proteins. Now what is in the vaccine? The vaccine is made of mRNA wrapped in a coating that ensures that the delivery is easy and keeps the body from destroying it. Now how does the vaccine work? The mRNA in the vaccine teaches your cells how to make copies of the spike protein, and if you are exposed to the real virus later on, the body by that time has learned how to make the antibodies, how to fight it off. Now these mRNA COVID-19 vaccines, they use the codes for the spike protein, which was also used by SARS-CoV-2, and it uses the body's own protein manufacturing center to make these viral proteins. The immune system then creates the antibodies. It responds by creating these antibodies. Now what are the advantages of this mRNA technology? One, it is easy to manufacture, and plus it is flexible since the sequence can be easily modified for different pathogens, and also probably in the future it can be used for therapeutic proteins. It can deliver therapeutic proteins also, and probably to treat some cancer types also. Now what did Carico and Weisman, the people who won this Nobel Prize, what did they do? They recognized that the body's dendritic cells, they recognize the genetically engineered mRNA as a foreign substance. Therefore, they produced different variants of mRNA, each with a unique chemical composition, which they deliver to the dendritic cells. Now, because of these alterations, the inflammatory response was almost abolished when the base modifications were included in the mRNA. Therefore, it is a significant development in the field of medicine. Thank you.